All right, Mr. Abraham, who are we ready on?
We are ready on Mr. Skelton's writ, please.
Right. Go ahead and have them step up. This is cause number WR 23-92, writ seeking bail reductions. Ezekiel Warz versus the state of Texas. Good afternoon, Mr. Skelton. Do you want to call your client to this hearing? Do you want
we have my client has made a bond on the charges here in Van Zandt County, and so the issue with I guess lowering the bond is moot right now.
Okay, you said that he has made the bond in this writ.
Made a bond, yes.
Okay.
I discussed it with Mr. Hartwell, and he's prepared to make a bond for the San Antonio matter, but there's been a clerical error down there. We're trying to get that cleared up, so we'll get back to Mr. Hartwell then when that happens.
Okay.
Thank you, sir.
All right. Well, thank you, Mr. Skelton. I appreciate the update. So the court will find that Mr. Warz is withdrawing the writ on the basis of him making bail.
All right. Thank you, Your Honor. Mr. Hartwell, thank you.
Hank, it's good seeing you.
Good seeing you. Thank you, sir.
All right, it's your turn.
All right, who else is ready?
Mr. Manning.
Judge, we're ready on Mr. Zimmerman.
Michael Cody Zimmerman, CR 22121, and writ WR 2395. What do you want to proceed on first, the writ or the criminal case?
Judge, what was the cause number on the? Is it 23121?
On the writ or the criminal case, the indicted case is correct. CR 23-121.
Okay. Judge, we can go ahead and proceed on arraignment. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty at this time and requests to be set on the pretrial docket.
Okay. Court finds that Mr. Zimmerman has waived the formal requirements of arraignment. He misspelled correctly. He understands what he's charged with. Court enters his plea of not guilty into the record and sets this matter for pretrial hearing. Do you want that December date or that January 4th date?
Judge, if we may, I just learned about it being indicted today, so if we can set it off to the January date.
All right. Court sets Mr. Zimmerman for pretrial on January 4th. That'll be at 1:30 unless he makes bail. If he makes bail, then the hearing will be held at 9 a.m. on that same date. All right.
Judge, and that was the next matter. We've reached an agreement on the writ. And the substance of that agreement is that the state has agreed to PR bonds on all but the charged case, the indicted case, the CR 23-121, and we've agreed to a bond reduction of $5,000 to $5,000 on that.
$5,000 on the charged case.
That is correct, Judge.
Okay. And then personal bonds and what amount on the other cases?
I believe it's just whatever I alleged in the motion. So just convert those to personal bonds.
All right, so 15,000, 10,000, 1,500, 1,500.
That's correct, Judge.
Okay, so Mr. Zimmerman has one indicted second-degree felony, one unindicted second-degree felony, one unindicted state jail PCS, one unfiled misdemeanor POM less than 2, and one misdemeanor driving while licensed invalid with previous conviction. Is that correct?
Your Honor, I believe the second degree felony that was on there, I believe that is actually the indicted case. So I believe it's just the unindicted state jail and the unindicted unfiled misdemeanors.
That is our understanding, Judge.
Okay, So the indicted case was included in the writ rather than a motion.
Judge, that is correct. When checking the cases prior to filing the motion, did not find that he had been indicted. But as I said, I learned today that he had been indicted, and so that would be a request for reduction on that.
Okay, so let me restate just so I'm clear. So the agreement between the state and the defendant is for bail to be set at $5,000 on the second degree felony offense. Possession of controlled substance, felony group 1, 4 grams to 200 grams. $10,000 on the state jail felony, so $10,000 on the state jail felony, but as a personal bond, and then $1,500 on the remaining misdemeanors.
As personal bonds, yes, Judge.
All right, court will review that. All right, so we've got him set for pretrial on January 4th. Okay, all right, so Mr. Zimmerman, if you make bail, then your hearing will be at 9 a.m. on that day. If you do not make bail, then we'll have your court hearing at 1:30, just like we are now.
Yeah.
Okay, what are we ready on next?
Judge, ready on Mr. John Orndorf.
Mr. Orndorf, CR 16-55, motion to revoke. Go ahead, Mr. Manning.
Judge, I received an offer from the state today. After speaking to the probation department and to my client, I'm going to propose a counter offer. I would request to be set off on something other than the contested docket. I don't think this is going to go into contested.
Well, let's go ahead and put him on that contested docket day, just because I don't have another setting between now and then that's not already full. So we can set
Yes, Judge.
Thursday, November 30th. All right, who's next?
Judge, let's do Mr. Ronnie Cotton.
Ronnie Dwayne Cotton, CR 22-240 for Dr. Paul.
Yes, Judge. We have not received a offer at this time. And I had not had an opportunity to speak to Ms. Curry about this case. I believe she's the one that was handling this. So I request additional docket call for me to discuss possible resolutions for Mr. Cotton's case.
Are you sure there's going to be an offer? Because this was indicted in September of 2022, so we're well over a year. We've had 1, 2, 3, 4, 5 pretrials, 2 arraignments, 5 pretrials, and a docket call. If an offer hasn't been made now, will be made.
Your Honor, I believe I can speak to a little bit of that. There had been some discussions between the state and defense. I don't believe a formal offer was ever tendered, but it's not that there haven't been negotiations or discussions. I just believe that no formal offer had been reached pending some of the details of those discussions.
Do you
That
know-
is correct, Judge.
Do you know, Mr. Harwell, if an offer will be made? Because I don't want to reset it for an offer to be made if an offer is not going to be made.
Your Honor, I couldn't speak to that with any certainty. We only really discussed this briefly yesterday. And as Mr. Manning stated, this is one that I haven't been working on. So I couldn't speak to that. I would expect that I would expect that an offer would be made, but I couldn't promise the court that.
All right, I'm gonna set it for final docket call on December 14th. If no offer is made that day, if no offer is made between now and then we'll just place it on the trial docket.
Yes, Judge.
All right, who's next?
We haven't done Nava yet.
Yeah.
Okay. Judge, we're gonna be proceeding on Mr. Nava. Here just momentarily, so if we want to, we can take up Mr. Davis at this time.
All right, Mr. Davis, if you'll come forward. This is in cause numbers CR 22-176, CR 23-124, CR 23-125, CR 23-149. State versus Michael Edward Davis. It looks like we have two set for Dr. Paul, one for pre-trial, and then the newest one, CR 23-149, appears to be set for arraignment. Let's go ahead and arraign Mr. Davis on man delivery charge.
Judge, I do not have a copy of that indictment as our last setting was a motion on the motion to withdraw. Judge, and in speaking to my client, he believes that we did do the arraignment last time, but it was just carried forward because of the motion to withdraw.
Double check, make sure.
Yeah.
Yeah, that was done.
Yeah. Okay. Judge, he said it was done, but he does recognize that his name is spelled correctly. He understands the charge against him, and his plea is still not guilty to that charge.
Okay. Court will find that Mr. Davis has formally waived arraignment, or if it hasn't already, will enter his plea of not guilty into the record. Sets this matter for pre-trial along with cause number CR 23-125. And are any issues on that 125 charge, evading arrest?
Judge, I'll tell you, I have gone over the discovery with him in his earlier cases, but I have not gone over the discovery in 125 or 149 to my recollection, as those were more newly indicted cases.
Okay. All right. Court will set Mr. Davis then for pre-trial on the evading arrest and the new man delivery for December 14th. Is that sufficient time, Mr. Manning?
Judge, I believe so. As I stated earlier, we're still waiting on a resolution for the motion withdrawal, which was submitted and heard on our last court setting.
Court's going to set Mr. Davis for docket call on December 14th as well. And the court, having considered the motion to withdraw, is going to deny the motion to withdraw. The court maintains Mr. Godfrey as attorney counsel record for Mr. Michael Edward Davis on the ground of indigency. Mr. Davis has not retained his own counsel at this time. So, Mr. Manning, court denies the withdrawal of this.
We will be ready on the 14th, Judge.
All right, who's next, Mr. Mead?
Judge, Mr. Nava is finishing up the paperwork for his probation. And then after he's done, I need just a brief moment to talk to Miss Allen.
Okay, and then Mr. Mosley. You have Justin Ryan Mosley.
Yes, Judge, I'll speak to Mr. Mosley as well.
All right, thanks.
What?
Took a break.
Did he?
Fine.
Oh,
As he said, I'm gonna talk to him in a minute, and then you wanna talk to Miss Allen, and he said, okay, fine. Okay.
Mr. Nava, you live on Bay Street?
Yes, ma'am. You need me to get up.
Give them to the judge and then to Mr. King.
You ready? You're not. It's fine. 4 years.
4 years. No, you were on probation. You've signed it twice. Probation is not recommended about probation. Yeah. 4 years. 2 years. Yeah, so you have to serve at least 2 years. Minimum. Is that aggravated offense? Okay, we'll say that next time. Well, because you are, right, you are on the probation, right? So they have a full range contract, so you get just 20 years. So you're not getting them in just 2 years, but you're getting close to, yeah. 4 years. 4 years. Yep, probation. You can make it up right off. You have to serve at least that time, but if you do well down on the roll, or if you do well, or your parole here, then you'll be released. You can be released. 2 years. And you get all your back time credit, all credit you serve now, we'll go towards your. It won't be today, but you can, the next setting of 2003. Yes.
Okay.
So this is so this is what's, is this what's added, Karen? Is this added or is this,
Yeah, what he had was,
so is it this plus this?
no, it should be, it is all. The remaining court cost is 118. Prior attorney fees was about 1260.
That's gonna be how long. So you can do that?
For now. He said they're ready when we are.
Ready?
Yeah.
How long is office? So.
Ready?
Ready on all three.
We're ready, Your Honor.
So am I. Who do you want first?
Judge, if we can have Mr. Nava.
All right, Alexis Nava, TR 20-185. You said this is going to be a revocation today, Mr. Henry?
Judge, it's actually gonna be a reinstatement.
Okay, what are the terms?
Terms of the reinstatement are that he is he is submitted to a period of imprisonment of 90 days. He is going to be put on the mental health initiative through the probation department. And he has also had an amendment to his court costs, which include the amounts that were incurred with this revocation. So my attorney's fees as well as the other amounts that were incurred as a part of the revocation.
Okay, and probation is supportive of this resolution?
I spoke to Ms. Burns about it, and she did indicate they were willing to take him back on probation with those caveats in place.
And there's an allegation in count 1 of a new offense. Is that resolved?
Good.
Your Honor, we haven't filed that case yet. I believe we have just received it, but I haven't had a chance to review it yet. So that case is still pending. We haven't been able to resolve that because it just hasn't been reviewed at this point.
And Judge, I would point out that the victim has provided an affidavit on prosecution in that charge. She has also spoke to my office multiple times regarding her wishes that not be prosecuted.
I'm reluctant to place him back on community supervision if the state ends up filing an assault family violence charge against him. So what I would propose is that we reset to November 30th, the state review the case and make a decision as to whether it wants to go forward or not, because that's honestly going to affect, it's going to affect my decision on whether or not I think he's a good candidate for probation.
And Judge, if I may, I think part of the concern that may be whether or not he's a good candidate for probation is going to be getting him on that mental health caseload and getting him the help he needs. He has been in jail for quite some time awaiting this revocation, and I've been negotiating with the state in attempts to get both wrapped up together. Unfortunately, we weren't able to reach that today, but I think if we can get him out on probation, if we can get him the mental health treatment that he needs, he should be able to show the court that he is a good candidate for probation. And if the state chooses to file them, we can deal with that when it comes. But he can continue doing what he was doing prior to picking up this new offense.
Or what do you think?
Your Honor, I do think that the affidavit of non-prosecution does weigh into our decision-making. Mr. Nava's willingness to engage in mental health services through probation, I think, also weighs into our decision. I think a big part, the three of us, Mr. Manning, myself, and Ms. Burns, spoke about this this morning after this morning's docket. And I think with probation's with their willingness to accept him back on probation, all of those factors considered, I think even if we were to proceed on the charge, and I've been able to read the offense report, but I haven't been able to watch body cam or look at any of the other evidence. So that's where my hesitation is in moving forward in that. But I think if we were to move forward with that, it may be something where probation to add it with his current probation conditions, or I may read it and see that it is better suited as a misdemeanor or something like that. Having spoken with probation and their awareness of the charge and willingness to take him back, I do think it speaks to Mr. Nava's ability to be successful on probation.
What if we granted Mr. Nava a personal bond, let him get out of jail? I'm assuming he's already done his 90 days. Is that correct?
That's correct, Judge.
So there's no more time to serve. What if we just,
Correct, Your Honor.
What if we just court grants him a PR bond? We reset November 30th. Mr. Hartwell, you review the case, determine whether you're going to proceed with it or not, and then we're all in a better position to know, Mr. Nava especially, as to whether or not he's going to have another case to fight. The court's going to know whether it should put somebody back on probation who, if the state proceeds with a case, has committed a new offense during the term of community supervision. Obviously, I don't want to put him back on and having you put back on probation while the state's trying to prosecute him on another crime that happened during the period of community supervision. That kind of looks absurd for the court to do that. So I think the middle ground here is we'll let him out of jail and reset to say November 30th, and gives you three weeks to look at it and file it if you want to file it. Don't if you don't, we can resolve it. If you want to write a CC, or you want to dismiss it, or you want to do something different. I think I'm more comfortable with that than just seeing that there is a new crime allegation that's not being attended to today. Or
Yes, Your Honor.
Or if you want to, I'd say you could withdraw count one, but I mean, I know it's out there, so that's going to give me hesitancy either way.
Judge, if I may just have a moment to confer with my client.
Yes, please. Go ahead, Mr. Manning.
Judge, after explaining what the court is proposing, he is fine with proceeding in that fashion, by resetting and seeing what happens with the case in the future.
All right, so the court will set Mr. Nava for hearing on the motion to revoke on November 30th. Court will grant Mr. Nava a personal bond today in the amount of $5,000. Court will have that order sent out to the Van Zandt County Justice Center. And then let's look to have some kind of position on the new alleged offense before November 30th by the state.
Yes, Your Honor.
And Judge, I have informed my client that he is still on probation and he does need to comply with all conditions of probation and conditions of bond that would be on his case.
Thank you for doing that, Mr. Manning. Mr. Nava, you've heard Mr. Manning, that is in fact the case. You are on conditions of community supervision. Should you violate any additional terms, then that could be added to your motion and it could ruin the deal that you have tried to secure today. Do you understand that?
Yes, sir.
And Judge, as a step of good faith, I'm going to recommend that we still proceed with him being put on the mental health caseload. And if we need to file an agreed amendment to that, for him to start getting the services he needs now.
Okay, I'll let you take that up with Ms. Burns at the probation department about getting that paperwork ready. You can agree. Your client can
Thank you,
agree.
Judge.
All right, who's next?
Judge, ready on Miss Allen.
Billie Jean Allen, CR 21-318, motion to revoke. Go ahead, Mr.
Judge, we received an offer yesterday. I was able to convey that to my client today. She accepts the state's offer of 4 years TDC and requests to be reset for the November 30th docket.
All right, court sets Ms. Allen to enter her plea on November 30th at 1:30.
And Judge, also just to correct the record from our last court appearance, I misspoke. Miss Allen is not charged with a new offense. I had mistaken her with another of my clients' paperwork, and so she is just here on the motion to revoke. She does not have a new charge. She would ask me to make the court aware of that when we came back up before you.
All right, thank you, Mr. Manning. I will note that. Thanks for bringing that up, Ms. Allen.
You're welcome. And last judge had Mr. Mosley.
All right, Mr. Mosley, come on up. CR 21-86, State versus Justin Ryan Mosley, pretrial. Go ahead, Mr.
Judge, we have received an offer from the state and my client wishes to accept that. We request to be set on the earliest possible date for a plea. It will be for time, but we would like to get it taken care of.
All right, let's go ahead and do that November 30th date. My 28th is at max capacity at the moment. So
Yes, Judge.
set Mr. Mosley for plea on November 30th at 1:30.
Yes, Judge.
Ms. Abraham,
Your Honor.
once we conclude with this docket, I'm gonna, I've got the family law hearing at 2:30. If you would prepare me in PR bond, or not PR bond, but a personal bond. Just an
Yes,
order
Your
on
Honor.
for Mr. Nava. I will get that signed so we can get that out there. So we can release.
And Judge, I believe the order on Mr. Zimmerman was e-filed.
Yes, I do have that one. I've got it right here.
Excellent. Thank you, Judge.
I believe that concludes. You can thank Patty for that.
May
Patty keeps everything squared away. Yes, sir, you may be excused.
Thank you.
Anything else out there at the jail that we need to do? Patty, are we done? And Patty must be mad at me. He's just hung up on him. Straight up. Did you see that, Mr. Hartwell?
I did, Your Honor.
I'm sitting here in my mind, recounting, what did I do to Patty today? She's upset. Now I gotta live in that fear until she comes back over here to the court. And y'all say a little prayer for me. All right, we'll see you, Mr. Hartwell.
Thank you, sir.
Okay.
You too. Bye-bye.